Hello, everyone. Welcome. I think we might get started, given that it is evening in Australia. I know that we have some international guests in attendance, including our esteemed presenter, Alan Bogg. So it's really great to have generated interest from around the world with this seminar tonight, which is the first labour law seminar of the year. So for those who don't know me, I'm an associate professor at Melbourne Law School and co-director of the Centre for Employment and Labour Relations Law. And before we get started, I would like to acknowledge that I'm currently working on the unceded lands of the Wurundjeri people, and I would like to acknowledge their elders, past, present and emerging. So in this seminar, we will be discussing two decisions of the High Court of Australia, which were handed down earlier this year. And they were very much anticipated, highly anticipated decisions, that of CFMMEU and personal contracting and ZG operations and Jamsek. And both these decisions are principally concerned with the legal test to be applied in determining whether the contested contract is one of employment. It's a foundational question. It's a question we start with at every, really virtually every labour law subject that is taught in this law school and around the world. But it's fair to say that in adopting a contract-centric approach to the characterisation of work relationships, these decisions have rocked the foundations of labour law in Australia. And we're already seeing responses to these decisions in the rewriting of contracts by Deliveroo, for example, in trying to ensure that those workers remain independent contractors under the common law as it exists in Australia. So in dismissing the relevance of the economic realities approach and downplaying a host of other factors, such as the inequality of bargaining power, these decisions mark a departure from the emerging jurisprudence in other countries such as the UK, and we've got Alan to sort of discuss the intricacies of the UK Supreme Court approach and contrast that with what's happening in Australia. So the first speaker tonight will be my colleague, Professor Sean Cooney. He has a long-standing interest in international and comparative labour law, and between 2014 and 2016, Sean served as a legal specialist in the Labour Law and Reform Unit at the International Labour Organisation, where he provided advice to governments in countries such as China, India, Myanmar and Pakistan. But thankfully for us, Sean has returned to Melbourne Law School, and but with this newfound knowledge about international instruments and how they apply in Australia and elsewhere. Our second speaker will be Professor Alan Bogg, who has been at the University of Bristol since 2017. Prior to that, he was Professor of Labour Law at the University of Oxford. Alan has an expansive interest in all areas of labour law, but a particular interest in judicial reasoning, which is very useful for our seminar tonight. And I understand he's got a forthcoming book called Landmark Cases in Labour Law. So each of the speakers will talk for approximately 20 minutes, and we hope to have some time at the end for questions or comments. So please feel free to use the Q&A function in Zoom, and I'll be monitoring that closely throughout the seminar. I should also note before we get started that the session is being recorded and will be made available via the Centre website. I hope to circulate a link to the recording through the email distribution list of the Centre, as well as the broader LLRN email network. So over to you, Sean. Thank you.
Oh, thanks, Tess. And I also would like to acknowledge the traditional owners of the land that I'm on, which are the Wurundjeri people of the Kulin Nations, and pay my respects to their elders past, present and emerging. So I think we've got two audiences here. We've got some people internationally who might not be very familiar with what's happened in Australia, and then other people in Australia who know very well what's happened but might not be so aware of what's happening overseas. So I'll try to cater to both of those, firstly by talking a little bit about the decisions, but not in a lot of detail, and then moving on and talking firstly about the position at the International Labour Organization, and looking particularly at one of its key instruments in this area, and then surveying some other jurisdictions, both common law and civil law. And then Alan's going to go into the UK in a lot of detail. And I had a quick conversation about what if people ask about the EU, Alan, can you do that? And he said, yes, so thanks. If you have a question about the EU approach, we can talk about that too. I'm not going to particularly cover that. So I'll just start off by saying that in recasting the common law of employment in Australia in the decisions of personal contracting and Jamsek, a majority of the High Court appears to be uninterested or even dismissive of overseas developments. And the majority seems to prefer a private law focused imagined orthodoxy that denies the legal relevance of actual relationships as opposed to legal constructs. And in doing so, the court has set its face, I would say, against developments in other jurisdictions and has ignored international labour law. So my goal here is to encourage people, especially in Australia, to nevertheless stay connected with what's happening in the wider world. I think there's a real temptation. Certainly advocates have to shape their arguments towards what the High Court has said, but at the same time, I don't think we should lose sight of there's something beyond our borders, and what's happening in our borders is pretty uniform. And it might mean that what we're doing in this country is really out of step. And of course, in terms of correcting the situation, I think we now need to look at legislative intervention. So let me first talk about the two decisions. Of the two decisions, the more important one in terms of explaining the reasoning of the majority of the High Court is the personal contracting case. And in that case, 5 judges tied closely the characterisation of work relationships to so-called orthodox contractual principles. And as a result of that, the characterisation now solely depends on the parties' legal rights and duties, and in case at least where there's a comprehensive written contract, only on the contractual terms as they're interpreted in the light of the surrounding circumstances, the objective surrounding circumstances. So this means that post-formation conduct is not relevant unless it alters contractual rights, such as through variation. So I will take you to some of the quotes here. So I'll screen share. So here's a quote from the court. This is from the plurality judgment. The only kinds of rights with which courts of justice are concerned are legal rights. The employment relationship with which the common law is concerned must be a legal relationship. It is not a social or psychological concept like friendship. There is nothing artificial about limiting the consideration of legal relationships to legal concepts such as rights and duties. By contrast, there's nothing of concern to the law that would require treating the relationship between the parties as affected by circumstances, facts, or occurrences that otherwise have no bearing upon legal rights. Now, this is a very strong statement that sits at odds with most other courts, which would say, hang on, there is a concern here, which is not just maintaining the architecture of so-called orthodox contractual principles. Now, there's a couple of qualifications to this. One is that just a contractual label characterising relationship can be disregarded insofar as it's inconsistent with other contractual provisions pertaining to rights and duties. Now, this exception seems to me to sit uncomfortably with the reasoning in the rest of the case, because the court then says the party's legitimate freedom to agree upon rights and duties should not be misunderstood. It does not extend to attaching a label to describe their relationship, which is consistent with the rights and duties otherwise set forth. So in the contract, that is not in reality. To do so would be to elevate their freedom to a power to alter the operation of statute law to suit themselves, or as is more likely, to suit the interests of the party with the greater bargaining power. But this is the only time in the judgment where, at least for the plurality, that bargaining power is at all relevant. And the judges go out of their way to say in other circumstances, bargaining power is not relevant. Now, a second qualification to this focus on contractual rights and duties is that it's still possible to make arguments based on equitable doctrines or shams, but the application of those exceptions to work contracts is really left quite uncertain by the two decisions. So that's the situation in Australia. And I now want to move offshore and start looking firstly at the ILO. So the ILO has a recommendation called recommendation number 198, which deals with determining the employment relationship. So just if you're not too familiar with ILO instruments, there's a distinction between conventions, which are legally binding, and recommendations, which are not binding international treaties, but recommendations like conventions are made by the ILO's highest decision-making organ, which is the International Labour Conference. And the ILO constitution requires that recommendations be brought before the competent authority, the legislature in Australia or the government, for the enactment of legislation. So a recommendation, even though it doesn't rise to the status of a convention, has important effect. And the High Court's held in Victoria and the Commonwealth, for example, that you can rely on a recommendation to enact law in Australia under the external affairs power of the Constitution. We could get into a discussion about that in more detail, but broadly that's the position. So as I've put out here, there's a core statement in this recommendation, and that is that the determination of the existence of an employment relationship should be guided primarily by the facts relating to the performance of work and the remuneration of the worker, notwithstanding how the relationship is characterised in any contrary arrangement, contractual or otherwise, that may have been agreed between the parties. So this statement is linked to other parts of the recommendation, which say member states should have national policies for reviewing the laws and regulations in their country to make sure that they provide effective protection for workers who perform work in the context of an employment relationship. And so this statement is linked to the idea that an employment relationship is a really important vehicle for delivering many of the rights that are set out in other ILO instruments, particularly the conventions, core conventions around freedom of association and so forth, at least as a practical matter in many countries. Now, the recommendation is careful to distinguish what it calls true civil and commercial relationships. But in so doing, what a court should do is be guided primarily by the facts, and this is called, unsurprisingly, the primacy of fact, as opposed to the primacy of law or legal constructs. Now, this statement, we can see that it is at odds with what the High Court has done in three different ways. One is that it focuses on the purpose of the characterisation, as I've said, namely to provide employment protection. And secondly, it's focusing on the relationship rather than the contract. And that's consistent with the minority position in personal contracting. And third, it's looking at the actual performance of the work and not the contractual arrangements. The recommendation goes on and sets out indicia which are not notably different from indicia that have been traditionally accepted in Australian law. But again, with referring to those indicia, the emphasis is on how the work is actually performed. Now, the significance of this recommendation has been considered in a recent general survey by the ILO's Committee of Experts. The Committee of Experts is a body which includes an Australian, Professor Rosemary Owens, 20 such experts, and every year they review different conventions and other instruments to see how they are implemented around the world. So the 2020 general survey concerned the employment relationship and some other related matters. And in the general survey, the Committee of Experts emphasised this idea of the primacy of fact. So the true nature of any employment relationship should be established through an examination of the relevant facts In the event of any discrepancy between the established facts and formal documents, the facts must prevail. In accordance with the principle set out in the recommendation, known as the primacy of facts, as I mentioned, the realities of the relationship are dispositive and trump other elements such as the intention of the parties or the manner in which they describe their relationship. So that is really the core idea, the core approach that the ILO has taken, and I emphasise that this is linked then to all sorts of other conventions, some of which apply to independent contractors as well as to employees, but many of which apply only to people in the employment relationship. So the effect of those conventions would be significantly diminished if it's possible to narrow the range of workers that are covered by the employment relationship. So that's why this is a matter of very serious concern. So I want to shift now and have a look at some other jurisdictions. I'll leave the UK, as I mentioned, for Alan. But if we look around the world, we'll see that most jurisdictions, at least that I've looked at for the purposes of this, do recognise the primacy of fact in some way. Now, I'll just start off by talking a bit about the US. So the US is actually a very, as you probably know, very complicated jurisdiction because it's got a variety of tests varying from state to state. Unlike Australia, there's not a uniform common law in the United States. And the other reason there's a lot of variation is that the tests respond to particular legislative provisions. So, for example, in relation to the Fair Labor Standards Act, you've got an economic reality test developed by the US Supreme Court. And that applies rather than the common law approach. But if we just take one of the more influential tests that's really gaining ground around the US, that's called the ABC test. And it's really strongly associated with the courts in California, and in particular with a decision called Dynamex by the Supreme Court of California in 2018. And following that decision, the California legislature incorporated the test into the California Labor Code. And we can see here it says, for the purposes of this code, a person providing labour or services for remuneration shall be considered an employee rather than an independent contractor unless the hiring entity demonstrates that all of the following conditions are satisfied. The person is free from the control and direction of the hiring entity in connection with the performance of work, both under the contract for performance of work and in fact, the person performs work that is outside the course of the hiring entity's business, and the person is customarily engaged in independently established trade, occupation, or business of the same nature as that involved in the work performed. Now, the application of this test or the provision in the California Labor Code was challenged by a number of platforms, Uber and Lyft and so forth, during the 2020 presidential elections, because it's possible in California to put have a ballot which can alter legislation. That was successful in relation to platform companies, not generally, but then the ballot has been set aside constitutionally for the moment. That's a lot of detail that we don't need to get into. Regardless of the outcome of that litigation as it pertains to platforms, this provision will continue to apply to at least non-platform labour in California and, as I say, in many other states. Another closer to home, very neat and elegant statement in the Employment Relations Act in New Zealand is Section 6, which says, in deciding for the purposes of the previous section, the application of the Act, whether a person is employed by another person under a contract of service, the court or the authority, as the case may be, must determine the real nature of the relationship between them. And there's a similar position this time in court decisions in Canada. So just to the last few minutes, talk a little bit about the non-common law position. I was going to do a tour of the G7. I won't fit everyone in. In France in 2020, their highest court, which is in civil court, which is the Cour de Cassation, has restated the principles for characterising a work relationship, and has emphasised that the existence of a labour relationship depends neither on the intentions expressed by the parties nor on the labour which they give to their agreement, but rather on the factual conditions under which activity is performed. So that's the French courts that have done that. In Germany, the matter is dealt with in the German Civil Code, and there's a provision that says an overall assessment of all the circumstances must be made in order to determine whether an employment contract exists. If the actual performance of the contractual relation shows that it is an employment relationship, the designation in the contract is irrelevant. And you'll find similar approaches in Japan. I've been in contact with some friends in Israel and Brazil, similar story there. And also in the Supreme Court of India has taken a similar approach there. So I'm not saying that there's no country which has the same position as Australia, but it's pretty hard to find it, at least in my recent searches. All right, so just to conclude, I might go back to the ILO and mention in a really important declaration setting out what the organisation was going to do in future as it reached its 100-year milestone. The International Labour Conference affirmed the continued relevance of employment relationship as a means of providing certainty and legal protection to workers. So the question is, well, is that the situation in Australia now? Is the employment relationship a means of providing certainty and legal protection to workers? And I think from what I've said so far, that we may be very much an outlier. So I'll stop there.
Thanks very much, Sean. We might now move straight to Alan's presentation, and then we'll revert for questions.
So thank you very much for the invitation. It would be nicer to be in Melbourne, I have to say. It's about 6 degrees here, and I've been rained on as I did the school run, so I'm sure it's warmer where you are. But it's nice to have the opportunity to read these cases and to reflect upon them. And I must say, I had a really kind of warm sense of nostalgia when I was reading through Jamsek and the personnel contracting case, because it took me back to when I first started studying labour law in the late 1990s in the UK. But I can't even say that the nostalgia was about the state of the case law in the late 1990s. The nostalgia was looking back 25 years back from there, because reading these cases, they really have a feel of a kind of 1970s style reasoning in employment status cases, at least in the UK. And it's quite interesting to me that in personnel contracting, that seems to me the key authority that was doing a lot of the work for the court was Chaplin, which is a kind of 1978 authority. And there have been many significant labour market changes, not least the fact of fissuring. And both Jamsek and personnel contracting are both instances of labour market fissuring. Yet there's no kind of contextual consideration of that in either of the judgments. So what I want to do is talk a little bit about the UK cases, and in particular, two Supreme Court judgments of importance, Autocleanse and Uber, and then reflect back upon where Australia now is, because it seems to me that there's a very significant bifurcation of approach, and it's useful to think about what that's about, how to understand it and why it happened. And I think the first thing I'd say by way of preface is I don't think it's an adequate explanation to focus on the conservative nature of the High Court of Australia and the kind of radical progressive credentials of the UK Supreme Court, because I actually don't think that's borne out by the facts. So the recent judgment in Uber in the UK was a relatively conservative panel. There was no Lady Hale, no Lord Kerr. It was a unanimous judgment delivered by Lord Leggett, and Lord Leggett, in essence, is a commercial lawyer, I think, and a mainstream private lawyer. So that, I think, is also interesting, that I don't think it's the kind of constitution of the court that really penetrates the significance of what's happening in terms of the kind of opening up of these judgments. So AutoCleanse in 2011 was a pivotal moment in the UK. It involved a comprehensive written document that purported to set out the rights and duties of the parties exhaustively. And those rights and duties were inconsistent with an employment contract, so a contract of employment between an employer and an employee. They were also inconsistent with a worker contract. Now, just by way of brief explanation, in the UK, we don't just have the common law contracts of employment, we also have an extended intermediate category of worker. And that's a statutory category with a statutory definition that extends wider than the common law contracts of employment. And that's used as a vehicle for certain rights like minimum wage and working time. The contract of employment, most importantly, is a vehicle for unfair dismissal protection. So that's an important difference of structure between the UK and Australia, but in AutoCleanse, nothing really turned upon that. It was a judgment that was speaking to both categories in terms of the general interpretive approach it articulated. Now, AutoCleanse is rejected by the High Court of Australia as an unjustified departure from orthodox contractual analysis. That's the way it's put in paragraph 51 of Jamsek. So it's worth pausing on whether or not that's true as a characterization. As a Brit reading those Australian judgments, what's really striking to me is how shallow the engagement is with the English case law. It's rejected very, very quickly. And in my view, it mischaracterizes what AutoCleanse actually stands for. And I think that's problematic. If you're going to reject a line of authority, you better think carefully about what it is you're rejecting. And I'm not quite sure the High Court of Australia got to grips with what AutoCleanse was authority for. I think there are two main propositions that came from AutoCleanse that were significant. The first is Lord Clark's emphasis on the distinction between employment contracts and commercial contracts. And that was based upon the inequality of bargaining power between workers, employees, and employers. Whereas in ordinary commercial contracts, there's a working assumption that the parties are able to look after their own interests through contractual negotiation. Now, it isn't right to say that there's a kind of roving doctrine of inequality of bargaining power that arises out of AutoCleanse. That's a misconstruction of how inequality of bargaining power operates in that case. It's not being used as a direct doctrinal tool. Rather, it's used as a normative principle to reshape some of the kind of intermediate rules of construction and characterization so that they operate differently in the domain of employment contracts. So the way I would put the inequality of bargaining power principle is that it's not directly operative like unconscionability, say. It provides an indirect underpinning to an intermediate set of rules of construction and characterization. And sometimes reading those Australian judgments, it's as if AutoCleanse stands for that direct rather than indirect form of the principle, and that isn't the case. So the second core element of AutoCleanse is that the focus of the tribunal should be on the true agreement between the parties. Sometimes that might be reflected in the written documentation, but not always. And in AutoCleanse, it wasn't, because there was a significant discrepancy between the performance of the contract and what was in the written documentation. And on that basis, the court took the view that it was open to the tribunal to look at the performance as a guide to what the true agreement was. Now, again, I'd emphasize that in many ways, this is not a kind of radical disruption of contractual orthodoxy. It is not dispensing with contract. What it's doing is it's modifying the rules of evidence used by the court to identify what the agreement is. So it's a kind of an adjustment within the contractual paradigm rather than a rejection of the contractual paradigm. So, for example, it would lead to a kind of reduction in significance of the parole evidence rule for ordinary commercial contracts, or the signature rule, which would usually be determinative in ordinary commercial contracts. But the focus is still on what was the agreement between the parties, not rejecting contract, but modifying the contractual paradigm. And I think, again, you would not get that sense from the rejection of AutoCleanse in the two Australian judgments. The third point is AutoCleanse now, I wouldn't say has been superseded by Uber, but Uber is a step beyond AutoCleanse. So in Uber, the focus there was on the intermediate worker category. You know about Uber. This is an arrangement where drivers use an app, they connect with passengers. The question is whether Uber, that provides the app, employs the drivers as workers, or is Uber simply a commercial agent setting up contracts between the passenger and the driver? And what the Supreme Court in Uber said was that they were workers on the basis of a purposive statutory construction of the employment rights. So actually Uber is interesting because it's moved beyond focusing on the contracts, and it's looking at the contracts through the lens of the protective statutes. So the question that the tribunal would ask of after Uber is looking at the protective statutes that are being claimed by the parties. Did Parliament intend that these arrangements should be regulated under the protective statutory regime. So it's an exercise in purposive statutory construction. There's still a requirement of contract, but the contract is very much in the background and the protective statute is in the foreground. So I think that's within the spirit of Alter Cleanse, but it's a step beyond Alter Cleanse in clarifying the importance of the statutory context. So I think what I'll do, having sort of set out Alter Cleanse and Uber, is just to think about how the bifurcation has come about. And before I do, incidentally, what I would say is that if you were to apply the Australian tests based upon these two authorities to the contractual arrangements in Uber, there's no doubt in my mind that the Supreme Court in Uber would have reached the opposite conclusion to the one that it reached in that case. So I think it would have been forced to conclude that the comprehensive written documentation was determinative. There was no obvious discrepancy between the written documentation and the working practices. It was a bad bargain, but it wasn't for the court to disrupt that bargain, and they would be treated as independent contractors. So that, I mean, you know, in stark terms, is what is at stake in this bifurcation. It's about the wholesale exclusion of workers in Australia who would otherwise be included on the UK approach. So I think there are kind of sort of 4 points I'd want to make about the bifurcation. And just to remind you, I reject the kind of conservative against non-conservative benches. I don't think that is sufficient to explain the divergence. So I think the first thing that's really striking to me is how in the Australian cases, there is very little consideration of the statutory context to the claims. So I couldn't tell you anything, having read those cases, about the statutory rights, about the purpose of them, what was Parliament's justification for introducing them. I didn't know anything about that statutory context, whereas in Uber, the statutory context to minimum wage regulation was absolutely central to the court's analysis of the problem. And I think in a way, what that suggests to me is that this kind of picture of the UK courts as being off on a radical frolic is really misconceived, because actually, in their own way, judgments like Uber are relatively conservative judgments in constitutional terms, because what the court is doing is it's taking the statute and it's enforcing the statute in accordance with parliamentary intention. And that shapes the process of characterization. So these are not kind of, you know, these are not radical left-wing judges off on a frolic. These are, you know, relatively mainline judges simply applying the statute to characterize the arrangements. And interestingly, Lord Leggett in Uber links this approach to section 203(1) of the Employment Rights Act 1996, which is the restriction on contracting out in the individual rights statute. So the point here is that if you defer to the written contract exclusively, that is what appears to be the case in Australia, the effect of that is to invite armies of lawyers to draft written contracts with the object of circumventing statutory protections. And for Lord Leggett, this would be to subvert statutory intention, because that's the very problem that the protective statute was introduced to respond to. So that's the first point. It's about the role of statutes in Uber and what Anne Davis has described as the primacy of statutes. The second point that I want to sort of briefly touch upon is the role of intermediate categories in UK labour law. So my understanding is that generally speaking in Australia, you don't have intermediate categories. And I think there's a kind of a significant degree of resistance to intermediate categories in jurisdictions that don't have them. Now, that's a big debate that I don't want to get into and can't get into, but let me just give you one feature of the role of intermediate categories in UK labour law that I think has been very beneficial. So we have this protective statutory category of worker, and the aim of it was to extend protections beyond the scope of the common law contracts of employment. Now, that was the source, I think, in the UK of this purposive protective approach. That's where you get this purposive statutory idea emerging into UK labour law in the court's reasoning. Now, what's happened in the UK is that there has been a feedback loop into the common law contracts of employment. So what I think has happened is that that's looped back round into the contract of employment discourse. Now, the effect of that has been to disrupt the common law foundations of the contract of employment so that it's increasingly been conceptualized as a subsidiary element in a protective statutory scheme. Now, I think it may be a weakness in the Australian context that the contract of employment is very deeply embedded in the common law mindset, and there isn't a vehicle for disrupting that. And in the UK, it has been disrupted through the intermediate category. So that's just something I'd ask you to reflect upon. The third point is this kind of idea in the Australian judgments, and I'll finish it up here, of the proximity to orthodox contract law and treating orthodox contract law as a kind of baseline for restraining the kind of unorthodox roving approach of the lower courts in some of your employment cases. That is a selective identification of the baseline of orthodoxy. So actually, in its own way, Uber and also AutoCleanse also fits with an orthodox analysis, but the relevant baseline isn't contract law. The relevant baseline is tax law. So if you read the Uber judgment in the UK, it's the tax jurisprudence that has been really influential in embedding the kind of what the Lord Legate describes as a purposive and realistic approach to construction. And that's linked to the Ramsey line of authorities in tax law. And in tax law terms, that is a perfectly orthodox approach. It is not an unorthodox approach. And in many ways, that gets to the heart of the regulatory problem in labour law. And the heart of the regulatory problem in labour law is how to cut through very complicated contractual arrangements that have been set up often in such a way as to avoid or evade statutory regimes of protection. So in those terms, the approach in Uber is perfectly orthodox. And what I would suggest to the Australian audience is the approach of the High Court of Australia is exceedingly unorthodox, out of step with international jurisprudence, and actually based upon a superficial and faulty reading of the UK authorities. And so that's a very strident way to finish, and that's where I'll end it. Thank you.
Thank you, Alan. I like strident conclusions. Look, that was fascinating. I haven't received any questions yet. While we wait for some questions to come through, I've got plenty of questions, and I'm sure Sean does as well. I wanted to kind of pick up one of the points you made as you led up to the strident conclusion, which is around the relevance of tax law, which I found really interesting and fascinating, because in Australia, under the Fair Work Act, you're quite right, we only have a common law concept of employment, which is relevant. But under our super legislation, our superannuation legislation or pension legislation, we do have an intermediate category effectively of work, or an extended definition of employment. And it is going to be very interesting, I think, to see whether or not we see more cases being brought under that superannuation legislation, which are trying to emphasise the purposive approach to employment characterisation and pick up and emphasise the elements that we're seeing in the UK judgments. So I just thought that was a really interesting kind of observation that came to me as you were talking. We do. Alan, there's a question that's come up about explaining what fissuring means. Did you want to expand on that?
What's that, sorry?
There has been one question about, can you please explain what fissuring means?
Oh, fissuring, sorry, of course, yeah, sorry, that was, so it's a term used to describe the disintegration of the kind of standard bilateral employment model. So you have a single employer directly employed in a bilateral relationship with an employee or worker. And what fissuring describes is a whole bunch of mechanisms used by commercial entities to reduce their labour costs. So franchising, subcontracting, using supply chains, recharacterising employees as independent contractors. I mean, Jamsek, they were basically doing the same job. They just changed the contract. It was identical in terms of what was happening, and there was a sole purchaser of their labour power for decades. So that's fissuring, and it's a term used by I think it might have been Professor Weil in the US, David Weil.
Yeah.
So sorry, that, yeah, I should have explained that. That's what it describes. It's this whole host of mechanisms of distancing to reduce labour costs.
Yeah, and I think personnel contracting is another example of a fissured workplace, in the sense of using labour hire to using an entity to place distance between the worker and the company which is benefiting from that labour. Sean, did you have any questions that you wanted to raise at this point while we wait for some of the...
I think there are questions that are coming in the chat.
Yeah, sure. So Sean, maybe you might want to expand on a legislative solution. What exactly would this involve? Have you got a vision?
Well, I think we need Andrew Stewart on board, because he's been arguing since, I was just looking at some articles he wrote in 2002, and then with Cameron Rolls 2015, that really look at what an Australian definition of employment would look like. So I don't myself have a pet solution. I've just showed you there's a whole lot of different ways of approaching this. But I do think especially if there's a government that's interested in addressing this question, which there may well be in a couple of months, that we need to look at this pretty carefully and go through the approaches overseas, but also some of the ones that have been developed by scholars in Australia, as well as you mentioned, Tess, definitions that have been used in specific areas of law, such as superannuation or workers' compensation and so forth. We do have an example, which is, while Australia's really going backwards, I would say, in this area, we have a world-leading approach to definitions in the work safety area. And that is where the language of employment has been almost entirely abandoned. Certainly it's not the central concept in work health and safety legislation in most of the states in Australia and federally. So even within the country, we're capable of developing something, but I think it will take a few conversations, and I'm not game to come up with a solution this evening.
Yeah, Alan, did you want to make a comment?
Yeah, so I think it's interesting to think about the role of statutory definitions and whether statutory definitions can improve things or not. And I think I kind of have two observations on that, really. The first is that even with an excellent statutory definition, if you have the kind of judicial approach that you see in your cases, it would be very easy for those statutory definitions to be subverted. I'm sort of reminded of Martha Nussbaum's work. She's done a lot of work on styles of judicial reasoning, and she draws a very important distinction between contextualist and formalist approaches. And contextualist approaches are, look at the doctrine, but are very sensitive to the reality of material disadvantage. Whereas formalist approaches just look at the contract, the words in the statute, without any sensitivity to that context. And what you see in those Australian cases, it is highly formalist. And even with a great statutory definition, if you've got that style of reasoning, that's going to be a persistent problem, I think. And I think the second thing is there's a real preoccupation in the Australian judgments with the rule of law and commercial certainty. That comes through very strongly. And I think in labour law, certainty isn't always a virtue. Certainty can actually be a problem where you're effectively signposting for well-advised employers with big teams of lawyers the way out of the statute. So sometimes a degree of fuzziness can enhance enforcement because it makes it less easy for lawyers advising employers to basically navigate their way out of the protective statutes. So those are just my kind of two cautionary observations on the role of statutory definitions.
Yeah, thank you for that. There's another question, and Sean, you might want to address this one in the first instance about Barker. So Gordon and Anderson and Jill Murray have raised a question about whether the High Court in Barker effectively, justifies the exclusion of the implied term of mutual trust and confidence by, referring to the statutory context. Did you want, and taking a very narrow approach to the UK jurisprudence on this question, did you want to discuss that at all?
I think this is from Jill and Gordon, right? Like, I think that it's sort of odd because Barker does spend a whole lot of time to say, well, the statute's there, therefore we don't need any common law response. But fundamentally, I think Barker is an illustration of the same kind of reasoning that Alan's just been describing, because it wants to go back to this imagined sort of common law, sort of contractual purity based around commercial ideas. And in Barker, as people might remember, they go back to this test for implied terms, the necessity test. and said, well, no, there's no necessity for it. So the statute came in as part of an argument around what is necessary. I always think in Barker it's interesting because no one's ever said, applied the necessity test to the master and servant provisions that form part of employment contracts, like the duty of obedience, the duty of fidelity. They're not justified in terms of necessity, right? But it's like anything else that comes in has to be justified on that basis. And again, sort of from sort of imagined orthodox contract rules about implied terms. So yeah, again, statute, there's a kind of byproduct. It's not a central focus.
Yeah, but it is interesting, I think, and I really liked the way in which you opened your presentation, Alan, by discussing the High Court judgments as having a bit of a retro vintage feel, And I think it is interesting because Australia has like such, statute is such an important cornerstone of our whole labour law regulatory system, and yet obviously it's been white-anted by these kind of very narrow common law judgments that are being handed down, or this very conservative approach. And one question that's come through, which might be the last question that we have time for, is in relation to the comments you made about taking the sort of political persuasion of the judges out of your analysis. And John Howe has asked whether or not that's a good idea, rendering visible the politics of the judges or not, even if conservative judges in the UK have taken this more kind of holistic approach or practical reality approach to the question of employment status.
Is that for me to respond? Yeah. So I think what I'm not saying is that the politics of judging isn't important. Of course, it's important. I think my point was probably a more strategic point, which is to say that there is a pathway of development open to the Australian court on the basis that I think there's no doubt it is a conservative court. And I think the approach I would take if I were trying to run these cases in Australia is to really take the line that the UK trajectory is a relatively conservative and orthodox trajectory. And I just think in emphasising that, it becomes potentially more attractive to the bench that you've got. And the truth is, you've got some of those judges for quite a long time. And I used to work with one of them back in Oxford. I should have dragged him along to a labour law seminar, and he might have thought differently about those cases. So yeah, it's a strategic point rather than saying that the kind of politics of the bench doesn't matter. It does. But it's fascinating to me that we don't have a radical Supreme Court in the UK, and yet we got here and you didn't.
Yeah, well, that's a really great way to finish. So thank you again for your time, Alan. Thanks for all the questions that have come through and for your attendance, which is now fairly late in the evening in Australia. So very much appreciated. Look forward to continuing the conversations about these sort of interesting cases. So thank you.